Hello, everyone. Greetings for the day. Through this presentation, we would be discussing the recent UK Supreme Court ruling in case of Uber. It's a very interesting ruling in the sense that the long disputed issue around the world was whether the drivers working for cab aggregators like Uber, etc., are full-time employees or they are basically independent entrepreneurs. So we'll go through this presentation and just to give you a brief of what we'll be covering. So we'll be covering the appellate hierarchy in the UK as it's slightly different from what we have here in India. And obviously the parties involved, the structure of Uber in UK and the holding company, etc. Then the major issues involved in this case, and then how Uber operates the entire business model, and then we'll be discussing what the agreements say. They have been discussed in the ruling. Then we would be discussing the statutory rights of the workers. Basically, the definition, the entire issue revolves around this definition and the licensing regime for operating cabs in the UK. Then we'll be discussing the major contentions of Uber in this case. Then proceedings before the employment tribunal. And then we move on to proceedings before employment appeal tribunal and the Court of Appeals. And obviously then the Supreme Court verdict. Then we also discuss the potential impact in the Indian context, because as I mentioned earlier, that this issue is not only in a particular country, it's all over the world and wherever the cab aggregators are operating. Then we move on to the closing and few open questions. So, we start with the presentation now. So talking about, just summarizing the ruling, it is actually a rap on the knuckles for the Uber by the Supreme Court. They have chided Uber for various reasons, which we will be discussing in detail. And there has been a surgical analysis, very, very in-depth analysis of the written agreements which the Uber has with its drivers and passengers. Then it was ultimately held by the Supreme Court that Uber is nothing but a transport service provider and is not a mere agent of the drivers. And the court went beyond the written agreement, and it has, reiterated the principle of substance over form, and also stressed upon the actual conduct. In the normal course, we come across situations that we see agreements are drafted in a manner that to kind of hide the actual transaction. But the court has specifically delved deep, as I mentioned, surgical analysis of the agreements, and they have ruled that you should focus on the actual conduct and not only what's written in the agreement. And it also says that one person cannot bind another without the other person authorizing it to act as it says. And so basically, it's a normal, principle of contract and agency, wherein you cannot bind another person unless that person has either, explicitly or apparently or implicitly authorized the other person to act as his agent. And again, one should focus on the reality of the situation, and the written document does not always reflect the real relationship. And it also highlighted that the bargaining power of the parties play a crucial role in how the agreements are worded. And it's normal that if in an employer-employee relationship, as an employee, you barely have that negotiation power, and which is what happened in this case. That all the favorite clauses, basically all the clauses are mostly in favor of Uber and leaving nothing for the drivers but to accept, because of course they want to work and earn money. And as I mentioned, they've chided Uber to use fancily worded agreements just to circumvent the law in that sense. So that's the executive summary. Now we move on to the detailed analysis, and So this is the appellate hierarchy for this. Employment Tribunal is the first appellate authority wherein this matter was the matter came for hearing in 2016. Then it moved. So basically, the Employment Tribunal held in favor of the drivers, which we'll be discussing what exactly were their findings. Then it moved to Employment Tribunal. Obviously, Uber appealed to the Employment Tribunal, Appeal Tribunal, which again held in favor of Uber. And then Uber moved to the Court of Appeals. And the Court of Appeals, it was a 3-member bench. So 2 of them ruled in favor of the drivers, and 1 of the member dissented and, ruled in favor of Uber. And we'll be specifically discussing the dissenting member's view. And then the final Supreme Court, where it obviously held in favor of the drivers. So the parties involved, the appellants, of course, 3 appellants. One is the Uber BV in the Netherlands entity, the Dutch entity. Basically, it holds, owns right in the Uber app. And the London, in UK, there are 2 entities. One is Uber London and the other one is Uber Britannia. So Uber London has the license to operate as a private hire vehicle in London, and Uber Britannia has the similar license to operate outside London but within UK. So respondents are, of course, various drivers without getting into the names. So this is how the Uber structure looks like. That Netherlands entity holds UK entities, and the app which Uber, we as a customer use and the drivers use is owned by the Netherlands company. Of course, now moving on to the issues involved. So 2 major issues. One is, whether Uber drivers fall under the definitions of workers' contract as per the employment legislation in the UK, or they are merely independent contractors and Uber is merely a booking agent for them. And if, the second issue is, if at all they fall under the category of workers, then what would be the working hours? How will the working hours be determined? So just to, move back a little. So the overall issue was that first, so drivers basically held that, we should be entitled to all the employment related benefits like paid leaves and the working hours, etc., should be governed by the existing laws. Whereas Uber said that, you guys are independent contractors and you do not fall in the existing definition of workers as per the existing employee legislation. So, for the second issue, wherein how do we determine the time? There were 2 issues where, that whether the time would be governed from when the driver logs into the Uber app. Of course, he has to be within that particular territory where he's licensed to operate and ready and willing to accept the trips, or the time starts only when they're actually driving the passengers to their destination. So this is the second issue. And now we move on. Before getting to the contentions, it's important to understand how Uber operates. Of course, most of us must be using Uber and most of us must be familiar with it, but it's always better to refresh. So Uber, of course, works on an asset-like model that they only own rights in the Uber app, and the cars are always owned by the drivers, who supposedly are freelancers or contract workers working at their free will. And all the costs related to, fuel, etc., maintenance are borne by the drivers. And then drivers' independence, I have intentionally put iron in the brackets, whether they are independent or dependent. That we'll come to know when we move on further and see how the agreements are worded. So as per Uber, they say that, drivers are free to log in and log out of the Uber app at their free will, which we normally know that, any driver is free to log in and log out of it. and they are not prohibited from providing services to other organizations. So as we know, like, normally we go to Uber, travel in Uber, we see that, say in India, there are other players like Ola. So they're free to, accept duties from Ola as well. So if any driver is sitting idle, they have two phones, they can accept any booking from Uber or Ola, they are free to decide. But are they actually entrepreneurs in their own right? That is interesting to see, because, when Uber came in India, some of the people then, left their good, regular jobs, and, they bought cars and got associated with Uber. So they felt that, we have that entrepreneurial feeling rather than, being an employee of anyone. Let's work on our own conditions. But interesting to see is that, whether are they really, independent in that sense, because a lot of restrictions have been placed by Uber, which actually on paper it may feel that, you are independent, but in actual they're not. Obviously, we'll discuss that how they're not when we move on to further slides. Then the fare fixing is obviously done by Uber, and the drivers have no say in it. Suppose if I have to go to place A to place B, my app shows me the fare and the driver has no say in it. And the driver has a leeway to accept a ride at a fare lower but not higher than the fare fixed by Uber. Now, this is, surprising, and also pointed out by the court that, no reasonable person will accept a ride at a fare lower than what is prescribed by Uber. So, it's practically, this condition is of not much of use. Then, Uber, of course, charges commissions, or you may call it service fee, from drivers for each ride on the fare fixed by it. And the commission percentages varies across geographies. It's normally 25 to 30%, to the best of my understanding. And the interesting part is the commission charged by Uber is always on the price fixed by Uber. So say if Uber fixes 100, and as per the agreement, the driver can accept it for 90, but the driver will always have to pay commission on 100. So, it's not at all logical to accept fare less than what the Uber prescribes. And of course, they don't have that leeway to take higher fare, of course, needless to say. And then penalty and compensation. Uber handles all the complaints. As we all know that if at all we don't like the car or anything, we don't go to the driver or we call the driver. We complain to the Uber on the app that, the car was not clean, so on and so forth. So Uber penalizes the drivers, but of course, only if there is any fault of the driver. And otherwise, if anything else, say a customer got late due to traffic, so obviously driver can't do anything in that. But as a goodwill gesture, Uber might have to refund to the customer to have that customer loyalty. So in that case, obviously they don't penalize the driver in that case. And if the customer damages any vehicle, or soil any seat, any of the seats, say anyone pukes, so obviously the cost is borne by Uber in that case. And then coming to the invoicing, that Uber, the app generates the invoice, and which, if you haven't seen that, it says on behalf of Mr. So-and-so, that Mr. So-and-so is the driver. So they issue invoices on behalf of the driver, and the invoice only has customer name and the driver's name. No vehicle number is mentioned, nor any other details of the customer are mentioned, like my phone number, etc. Nothing is there. Why it's not there? We'll come to it when we go ahead. So now moving on to what the agreements say. So broadly, there are two agreements. One agreement is between Uber BV, that is the Netherlands entity, and the drivers. And the other agreement is a tripartite agreement, which is called as rider terms. It is between Uber Netherlands and the local Uber company in UK and the user, the passenger or the user. So as per the first agreement between Uber BV and drivers, it says that it's a limited payment collection agent. So basically, Netherlands Uber Netherlands portrays itself as a limited payment collection agent solely for the purpose of accepting fare on behalf of the drivers. And, it says that they are just providing a payment processing facility. And it agrees that, payment made by the user, it specifies that, the payment made by the user to Uber Netherlands shall be considered the same as directly paid to the driver. So, if I'm paying cash, obviously it goes directly to the driver. But if I'm paid through my credit card, it goes to Netherlands. But the agreement is worded in a manner that it will be deemed that it is paid directly to the driver. And the interesting point is that the agreement with drivers is only entered with the Netherlands entity. So no local entity like the UK entity does not have any agreement with the driver. It's the Netherlands entity who enters into the agreement with the driver. And this is a very interesting observation which has gone against Uber. We'll come to it when we discuss what the court, observed and concluded. Moving on to the tripartite agreement. So the tripartite agreement, I would, like to read it out because it's very important to, understand what it says. I'm not sure if it's clearly visible. Apologies for that, but we'll share the PPT. You can have a look, and I'll make sure that the formatting is better. So yeah, it says that the Uber UK. So of course, Uber UK includes Uber London and Britannia, accepts private hire vehicle bookings, acting as a disclosed agent for the transportation provider as principal. So basically, this agreement portrays that the driver is the one who is providing transportation services, and Uber is just a agent acting on behalf of the drivers. It further says such acceptance by Uber UK as agent for the transportation driver. So I'll read driver instead of transportation provider going forward. So it says such acceptance by Uber as agent for the drivers give rise to contract for the provision to user of transportation services between the passenger and the driver. Now it says, for the avoidance of doubt, Uber UK does not itself provide any transportation services and is not a transportation provider. So Uber has repeatedly maintained this stance that we are not rendering any transportation services and we are merely an intermediary between a passenger and a driver. And it further states that passenger acknowledges and agrees that the provision to you as a passenger of transportation services by the driver, and that Uber UK accepts your booking as an agent, so, and is not a party to contract. So, as I mentioned earlier, in short, it says that it's the driver who renders the transportation services, and we have no role but only to act as an agent and collect service payment on their behalf. So now moving on to the next slide. The statutory rights of the workers and the licensing regime. So the statutory rights of the workers, if we see, now the drivers have claimed that statutory rights like minimum wages, annual paid leave, and other similar rights available to full-time employees in the UK should also be available to them. So the employee tribunal analyzed the definition of worker in the Employment Rights Act in the UK. Now I'll read out the definition, and so the emphasis have been supplied by me in bold and underlining. So I'll just read it out. An individual who has entered into or works under or where the employment has ceased, worked under a contract of employment. So that's a normal, contract a contract between an employer and an employee. Or, so the B limb is the most important, and which is the point of discussion in this entire scheme of things. So any other contract, whether express or implied, and if it is expressed, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not by virtue of the contract that of a client or customer of any profession or business undertaken carried on by the individual. So this definition has been broken into parts in the ensuing slides, so you'll be able to understand it better from there. So we'll come to the definition, once we go ahead. So now, and another important aspect is the licensing regime. So obviously, any vehicle driver needs to have a commercial license for the car and himself to drive as a commercial driver. And in the UK, even Uber is required to hold a valid license to operate as a private hire vehicle operator, PHV. And of course, it had that license. So this PHV operator license, so basically this license, the existence of Uber holding this PHV license also played a very important role in, for the court to decide against Uber. So now coming to the major contentions of Uber. So as I mentioned earlier, that it always has maintained that, it's not a transport service provider and is merely a collection agent. So it says once the driver accepts a user's ride request made through the Uber app, a legal and direct business relationship is established to which none of the Uber affiliates is a party. And that a driver is the one who is solely responsible for providing transportation services to the passenger. And that the only role of Uber BV is to provide technology services and act as a payment collection agent for the driver. That the role of Uber London and Uber Britannia is to act as a booking agent for drivers. And that the approach adopted by the lower appellate authorities of disregarding the unambiguous terms of the written agreements without any legal justification is incorrect. So basically, the lower courts, before reaching the Supreme Court, the lower courts clearly held that, the written agreements are worded just to, avoid the legal obligations, and we need to focus on the actual conduct and the substance over form principle. So, the Uber contended that you need to regard written agreements and you cannot, reject them. So now we discuss the proceedings before the employment tribunal. So in deciding in interpreting the definition of workers, the employment tribunal, I'll call it as ET from now for ease of reference. So ET relied upon a Supreme Court ruling in case of Bates Van Winkelhoff versus Side & Co. LLP. So which held that the employment law distinguishes three types of people. One is, of course, those employed under a contract of employment, like a normal employee-employer relationship. The second are those self-employed who are in business on their own account, like a normal business entity. And then the third is the intermediate class of workers who are self-employed, but they provide services as a part of profession or business undertaking carried on by someone else. So the point of dispute in the definition of workers is limb B, which I highlighted earlier, and which can be divided into key elements. So the definition of workers, which we discussed earlier, has been divided into three here. So it says a contract whereby an individual undertakes to perform work or services for the other party and undertaking to do the work or perform the services personally, and a requirement that the other party to the contract is not a client or customer of any profession or business undertaking carried on by the individual. Sorry, excuse me. So the ET acknowledged that the case is concerned with the first of the three requirements, that is a contract whereby an individual undertakes to perform work or services for the other party. So ET concluded that, it is not in dispute that the drivers worked under contracts whereby they undertook to perform driving services personally and it is not suggested that any Uber company was a client or the customer. So basically, what the ET is saying that the second and third condition is satisfied, that the drivers are performing those services personally, and for someone who is not their client. So Uber company is not their client in that sense. So the only point of discussion is point number 1. So the critical issue as per ET is that for the purpose of statutory definition, the drivers are to be regarded as working under contracts with Uber London, whereby they undertook to perform services for them, or whether, as Uber contends, they are to be regarded as performing services solely for or under contracts made with passengers through agency of Uber London. So, in short, what the ET analyzed, that whether the drivers, who should be regarded as working under Uber and they're providing services to Uber, or whether, as Uber contends, that the drivers are rendering services only for the customers directly, and we are just mere agents, collecting payments on them. So the observations of ET were very interesting. So when we discuss the the Uber business model, so that's the reason it was important, because those are the important factors which led to this conclusion by the ET. So it says, the remuneration is fixed by Uber and drivers has no say in it. And the notional freedom to charge a fare lesser than the prescribed is of no use practically. And even the service fee, the commission or the service fee, which I mentioned, it normally ranges from 25 to 30%, is the fixed by Uber, and the driver has no say in it. So effectively, it's Uber who is dictating all the terms. So how can you, if you claim to be an agent, then how can you dictate terms to your principal, right? So that was the entire point of the employment tribunal. And it says that, the entire contractual terms have been dictated by Uber. And it further mentioned that, although to the point that when Uber said, the drivers are free to choose, accept rides from any other competitor, the ET, clearly held that, that even if they have that choice, but the choice whether to accept request is constrained by Uber. And how is that constrained? That is, of course, Uber shares only limited information with the drivers. Like if I book a cab, the driver can only see my name and the rating. They cannot even, earlier at least in India, I don't know exactly, but until a year or two back, we used to have drivers' mobile number, and even the drivers used to have our mobile number. But then eventually, gradually, when in India, now we only see a landline number from which the driver calls. And if we reach out to the driver, they can also only see they cannot see our number. So it's a landline number. So in that sense, ET highlighted that, you control the information which you're sharing with the driver. Had the driver being an entrepreneur, you cannot impose such restrictions on them. And you are monitoring the rate of acceptance of the driver. So if, as a driver, if a duty comes and I do not accept, I am liable to be penalized if I accept less than 80% of requests which I receive during a day. So in that sense, ET highlighted that, even if the employee has a choice to accept rights from the other company, but, you have constrained those rights. So, they are not independent in that sense. And it's mentioned that, the above factors do place drivers in a subordinate position. And Uber exercises significant degree of control over the way in which drivers deliver the services. Like, they maintain a rating system. And if a driver's rating system falls below 4.4, so there are kind of, gradual messages going to the driver that, you should do this, that to improve the services. So the court's contention is that, you are basically not letting the drivers work free, at their freedom in a real sense, and you control significant degree of control on how they function and how they render the services. And it pointed out that, from a driver's point of view, the driver is not free to decide their own prices. So effectively, so in order to earn more, he has to remain login, for more hours and do more rides or for a higher value of rides. So he cannot improve his economic condition by not logging in for a reasonable period of time. So the ET concluded that it clearly held against the Uber, of course, that as long as any driver who has a Uber app switched on and is within the territory where he's authorized to work and is able and willing to accept assignment, is for so long as those conditions are satisfied, working for Uber and under a worker's contract. So clearly held that the drivers are working for Uber under a worker contract and are liable to all the benefits which the full-time employees are, can avail. And they also mentioned, that's it's specifically mentioned that it's surprising to see that the remarkable lengths to which Uber has gone to prove its point through twisted language of legal agreements. So it's stated that any organization at the heart of which carrying people from where they want to go to where they want to go, and operating in part through a company discharging regulated responsibilities. So basically, what in short they held that it's at the heart of Uber to serve its customer, to help them reach where they want to go, and Uber also has a PHV operator license, and just wanting the drivers to agree that it does not provide transportation services is completely unacceptable, and there's a lot of skepticism involved. And ET, so the ET's order is quite a detailed order, and they have really done a threadbare analysis of the agreements. And it specifically mentioned that, a driver enters into a binding agreement with a person. So it's talking about a tripartite agreement. So drivers enter into a binding agreement with a person whose identity he does not know and will never know. And who does not know and will never know his identity. So basically the customer also does not know driver. To undertake a journey to a destination not told to him until the journey begins, by a route prescribed by a stranger to the contract from, so basically the stranger is the Uber, from which he is not free to depart, at least without any risk, for a fee which is set by the stranger, that is Uber, and is not known to the passenger and is calculated by a stranger and is paid to a stranger. So basically they're saying that the driver has been bound by an agreement which a strangers enter for him. So Uber enters for him for a ride which he will, basically drive a customer whom he doesn't know for a fees which Uber decide, from the route which Uber decide, and the payment is also made to a stranger. Leave aside cash payments. So this is a very interesting observation by ET. So ET concluded that, any supposed contract between a passenger, so any supposed driver-passenger contract was a pure fiction, bearing no relation to real dealings and relationships. And, it further rejected any suggestion that Uber was working for the drivers. And in fact held that it's the other way around, that the drivers are working for Uber and not the Uber is working for the driver. So moving on to the proceedings before the Employment Appeal Tribunal and the Court of Appeals. So the EAT basically overall held that it agreed with the conclusion of the ET and held against the Uber, and aggrieved against the EAT ruling. It appealed to the Court of Appeal. And so the Court of Appeal ruling was presided by 3-member bench. And 2 of them were in favor of the drivers, and 1 of them dissented and ruled in favor of Uber. So I will not be discussing, what went in favor of drivers again, because mostly the contentions are same as, held by the ET. So we'll discuss the dissenting members view, because that's very important. So as, the lower authorities and the 2 members of the Court of Appeal upheld the principle of, substance over form, the dissenting member, chose to give literal interpretation to the existing employment-related legislation, and he consciously chose that one should not apply common law wherein judicial precedent. So basically, common law is where the judicial precedents set the law and not a codified law. So his straight point was that as per the current legislation, it does not protect the drivers. It does not protect the drivers to get covered, get the benefits of employees, the employee legislation in the UK. And the only way it can be changed is for the parliament to amend the legislation. So it clearly held that, the existing relationship, do not mistake the exact relationship. It is just that whatever is stated in the agreement is not currently taken care by the existing law. And he quoted an article in Oxford Journal, which says that, it stated that there is no doubt that 0-hour contracts are a matter of very concern. So 0-hour contracts are wherein basically there's no time limit, and those kind of agreements are 0-hour contract. This is because, so basically it says that, I'll just read out what the relevant portion it has reproduced from the Oxford Journal. It says, there is no doubt that 0-hour contracts are a matter of a great concern. This is because they are often, although not always, cynically constructed agreements framed by the employer in order to avoid their legal duties. I do not believe that the common law can successfully deal with them alone. Auto-cleanse. So auto-cleanse is a case which was cited by the courts for ruling in favor of the drivers, which we'll be discussing later. Auto-cleanse allows a court to deal with the cases where the agreement is a sham, but the problems arise when it genuinely reflects the way in which the contract is performed, although the worker would choose that contract were otherwise. The courts cannot simply ignore express terms or apply some general doctrine of unconsignability to invalidate a contract because of unequal bargaining power. So he pointed out that the whole question of whether and how to adopt existing employment law protections to development of the so-called gig economy is a matter which the parliament should look into, and it's under review of the government. And it is not for the court to just ignore the agreements just because those agreements are not in line with the existing law of the land. So that's what the dissenting member held, and he finally concluded that that parliament is inherently better placed to assess this matter rather than the court. So now moving on to the Supreme Court verdict. So on issue number 1, like whether they are working for Uber or it's the other way around. So principle of substance over form, Supreme Court majorly relied on what the lower authorities have discussed. So basically, the Supreme Court held that even if there is no written agreement between the local Uber entities in the UK and the drivers, it has to be inferred from the conduct of the parties that such relationship did exist. So as I mentioned earlier, that it was interesting. So in this slide, when I mentioned that it's interesting to note that the agreement with the drivers is only between Netherlands entity and the driver, and there is no local entity involved. Just a second, bear with me. Yes. So, as I mentioned here, that interesting point that drivers' agreements are only with the Netherlands entity, and no local Uber entity in the UK is involved. And which is what has gone against them. That the Supreme Court held that substance over form, and even if there's no written agreement, but the conduct so suggests that the drivers are being directed by Uber UK, so that the agreement was in place, irrespective that there is no written agreement in place. So yeah, let's just move on to the back to the slide. Yeah. So and it also mentioned that the licensing regime which we discussed earlier requires a PHV operator, private hire vehicle operator, to obtain a separate license, which Uber local entities in the UK possess. So court highlighted that the PHV operator license is a separate license which is not held by drivers. Drivers only hold a commercial license to drive the vehicle and for that particular vehicle which they're driving, and they do not hold a license to operate as a PHV operator. So this court highlighted that that the conduct that you are holding that PHV operator license, and despite that you claim that you're not a transport service provider, is not at all acceptable. So the Supreme Court held that the only contractual arrangement compatible with this licensing regime is where UK entities accept private hire bookings as a principle, and which they fulfill through the drivers who are working for them. So that's a very important point made by the Supreme Court. Then it moved to principles of contract and agency law, wherein they analyze the rider terms, the tripartite agreement. So, it mentioned that as per the rider terms, the Uber is entering into a contract with the passenger to bind the driver. So, which we discussed earlier, that, a stranger is entering into a contract for drivers, and they have to drive someone at a price they don't know, and the customer they don't know, and even the fees is paid to the Uber, and the route and everything is decided by Uber. So they highlighted the principles of contract and agency law, that it's only a trite law that person A cannot create a contract between person B and C unless A actually or apparently authorized B to do so. So in short, that Uber cannot create a contract between driver and the passenger unless Uber itself is authorized by the driver to act as its agent. And it's again highlighted, the driver is nowhere the party in the tripartite agreements. If you remember when we discussed that the tripartite agreement is between Uber BV, Uber local entities in the UK, and the passenger. So the rider terms, the driver is not even a party to it. And based on principles of contract and agency law, so it clearly said that nothing in the rider terms authorized the Uber local UK entities to act as the agent, and nor does it give any rise to any contract between the driver and the passengers. Though the court acknowledged that the agency relationship need not always be contractual, and an apparent act by principal, driver in this case, conferring authority on the agent Uber in this case to act on its behalf is enough. So they acknowledge that it's not necessary that it has to be contractual. Any act on part of the principal to show that this guy or this company will act as my agent, that will suffice. But in this case, they clearly held that in this case no actual authority was given by driver to Uber, and so basically this rider term agreement is not relevant if the driver himself is not a party. So it mentioned that even if there is no actual authority, a person who, as just kind of explaining what we discussed on the previous point, that a person who purports to act as an agent of another person may still affect B's legal relation with a third party. So basically, if Uber acts as an agent of the driver with the user or the passenger under a principle of apparent authority, but that is only if B has represented to the passenger that A is authorized to act. Basically, the driver has represented to the passenger that Uber is authorized to act as an agent. And, the passenger believes in that fact. And the ET never made such findings that, B made any act to make the user or passenger believe that Uber is driver's agent, because, practically driver and passenger don't know even each other. They only meet when they are, they're going, basically the passenger is going somewhere, and that's where it ends. So then it, pointed out the conduct that, you should focus on the reality where written documentation may not reflect the reality. And it also highlighted the role of bargaining power, so which we discussed a little while back. So Otto Glenn's case, which highlighted that the relative bargaining power of the parties must also be taken into account. So in this case, like the driver is having no bargain power, so whatever Uber says they'll have to accept. So this is how the Supreme Court held that the substance over form has to be looked into, has to be respected, and irrespective of what the written agreements say, and you cannot bind any other person without his explicit or implicit consent. The driver is nowhere a party to it, and the conduct is important, and which is what they decided that the Uber is the one who is kind of guiding them, directing the drivers, and not the other way around. And of course, the role of bargaining power. So this was related to issue 1. Now we come to issue number 2, which was if the court holds that the drivers are workers under the definition of the Employment Rights Act, then how will Uber determine the time? So the drivers always complain that we are being exploited because there are no prescribed working hours which we are governed by. So that was the exact the concern of the drivers. So this issue 2 was analyzed by the court. It says time spent by the driver working for Uber was not limited to periods when they're actually driving, but also included any period when the drivers are logged into the Uber app within the territory in which they are licensed to operate and are ready and willing to accept trips. Now, ready and willing to accept trips is a very subjective thing, but let's let it remain that way. Now, one interesting statement of the Supreme Court was that, which I feel is very incomplete, that this question was not answered appropriately, because the Employment Appeal Tribunal while deciding on this particular issue 2 said that practically so Uber mentioned that the driver's time should be counted only when he's driving the car from place A to place B, whereas the drivers contended that the time should start the moment I leave my home. I am logged into Uber app, so I am available for the duty. So it's not my fault that the duty is not assigned to me. So for them, it says the Uber app, if I'm switched on and I'm within the territory to drive, and I'm willing and ready to accept the trips. So the time should count from that time until when I log off at night. So the Employment Appeal Tribunal mentioned that the other concern of the Uber was that even if driver is logged into the Uber app, but we have given them free hand to accept rides from our competitors. So how can we allow that time wherein they're not driving to be treated as hours they're working with us, right? To which the Employment Appeal Tribunal said that, we agree to this contention, but, looking at the facts of the case and Uber's market share in London back in 2016, 2017, when the Employment Appeal Tribunal heard the matter, that, that even if the drivers want to accept the other booking, the kind of Uber, the kind of market share Uber has, they cannot accept any other competitor's booking. So this is what they mentioned, and this is what made them reach a conclusion that that they can, even if they want to, they cannot accept it. So you have to count the time the moment they are logged into the app, which I found is not correct. I mean, with all due respect, my personal opinion, that so in this sense, we cannot take a blanket. This ruling cannot be a landmark in that sense for the issue 2 in particular, that you need to address that issue, that the Uber in right in that sense. If an employee logs into Uber and Ola at the same point, and so basically with Ola also I'm being counted as working the moment I logged into Ola app, and with Uber also. So I feel that's not correct, and that's something that has left incomplete, and even Supreme Court did not answer this contention properly. So Supreme Court, so you can refer para 136 of the Supreme Court's ruling, that wherein they've left it completely open. They've not answered it. They've simply mentioned that we cannot answer this in abstract. So I feel that has not been addressed properly. Yeah, so as I mentioned, in my opinion, this question of time measurement remains fact specific and has not been answered on a principle basis, cannot be taken as a blanket approval. And this could create practical challenges while determining the working hours, because it will be difficult. I don't know how the companies will figure that out, but this will be a clear-cut challenge for them. Okay, now coming to the potential impact of this ruling in the Indian context. So in India, of course, the foreign rulings don't have an authoritative value, but they do have persuasive value. And I'm sure the principle of substance over form remains standard all across. So, which is the basis, the center, basically the central point of this ruling, that substance over form. Even if the agreement says something, you need to see much beyond that and look into the actual conduct, etc. So similar issue arose in May 2017. So as I mentioned, that this is not a new issue and limited to UK or India. This is a worldwide issue wherein the drivers want to get covered under employee benefits available to full-time employees. So in India also, Delhi Commercial Driver Union filed a writ petition before the Delhi High Court, wherein they requested that a committee should be set up, and requested the High Court to direct the Indian government and the Labour Department and the Transportation Department to set up a committee to monitor implementation of labour and social welfare laws with respect to relationship between Uber, Ola, and their drivers. And interestingly, Reliance was also placed on the ET's ruling. So at that time, only the Employment Tribunal ruling was available in case of Uber, and the point of contentions were broadly similar. So we're not going into the details of that. But surprisingly, that the writ petition was withdrawn in December 2017, and it's quite surprising why it was withdrawn. Okay, now what the union budget has in store for the gig economy. So the budget speech of the recent budget announced on presented on 1st February 2021. In paragraph 112 of the budget speech, it categorically states that social security benefits will extend to gig and platform workers, and it further states that the minimum wages will apply to all category of workers, and they will all be covered by the ESIC. While certainly this look promising, but I feel it's only on paper as of now, and it's of not of much use until it is implemented in reality. So the impact on other platform operators, I feel this ruling will have, maybe the issue is reignited in India with this ruling, and it could impact other aggregators like food delivery apps, Swiggy, Zomato, etc. However, it is not likely to impact the hotel aggregators because their model is completely different, which the Supreme Court has specifically dealt with how the hotel aggregator models are different from Uber, which is dealt in paragraph 104 of the ruling. Now coming to the impact on taxes, I feel so. Currently, the cab aggregators are liable to pay GST under the reverse charge mechanism, so they pay on behalf of the drivers, because still, these drivers are, it's kind of an unorganized sector, so it's the responsibility of the company to collect GST. So once the drivers are considered as deemed employees, I feel the GST will obviously go out of equation, because an employee rendering service to his employer is not liable to pay GST on it. But however, on the other hand, I feel it will be, it will raise revenue from the income tax at the income tax front, because currently, Uber, Ola deducts 1% TDS, tax deducted at source, of the contractors, of the drivers. And most of them may not be even filing returns. So department is only getting 1% of the gross amount what the driver earns. Whereas if they file return, they have to pay, liable to pay through, so basically as per the slab rates. So if once they become deemed employees, so obviously this income will be taxed as salary, and will be, so the tax deducted at source would be higher than what currently 1% is there. So I feel in that sense the government will get more revenue from income tax perspective. So having said that, obviously it will be a practical challenge to calculate the expected earnings for the entire financial year, as the earnings of the drivers will still be contingent upon the business they bring. And a clear set of guidelines to deal with such cases should follow. Once such drivers are deemed to be employees as per the labor laws. So in the previous one, what I'm trying to say is that as an employee, so today as an employee, a normal employee knows how much he earns in a year. So it's an annual CTC of say X amount. So employer knows, this is the bracket in which he'll fall, and they deduct TDS every month basis their expected tax liability. Whereas in this case, if the drivers are deemed employees, so I feel as an employer it will be difficult for me to anticipate how much amount at the end of the year that particular driver will earn. So maybe it's kind of a past year basis, so that kind of an average, or last year he earned this much, so maybe let's see how the things pan out. Right, now we move to closing. So given the emergence of new business model in the recent years, it has been challenging for sorry, I think some audio issue maybe. So given the emergence of new business model in the recent year, it has been challenging for the governments around the world to keep up the pace by carrying out corresponding amendments in the existing laws. So, it has not been easy, and the business models have been changing, quite drastically have changed over the last 5-10 years. And not only in this aspect, the governments have been facing challenges how to tax digital businesses, digital economy, and the OECD and the G20 countries are already, under discussions, and recently USA giving commitment that it stands by with the world at large to deal with this issue. So, irrespective of the unique business model that are in place, the following principle always hold an important place in any transaction. One is substance over form, which we normally, keep, repeating for our clients that, there's no point in today's time, if you're doing an agreement, make sure that the actual conduct coincides with what is written on paper. Because if that is not true, then your written agreement, you may get it drafted in as many fancy words and pay as much as you want for getting that agreement drafted. But if your actual conduct differs, that risk will always be there, and this substance over form can always be invoked. And of course, also, so yeah, I already mentioned that actual conduct and substance over form is the key. So open questions, I feel when the drivers, if at all, they become full-time employees. So either, they are restricted to, work with other organizations, and if they are not restricted, then whether they'll be treated as employees of, more than one organization at the same time. And if yes, then whether they'll be treated as part-time employees for each organization. So these are interesting things which are still open, and only time will tell how they are dealt with. And as we previously discussed, the working hours of drivers would be a difficult thing to calculate. So let's see how things pan out, and the overall tax implications are yet to be analyzed. So yes, plethora of questions once the employees are treated as employees of once the drivers are treated as employees of the cab drivers, and of course the compliance burden will only increase. So let's see how it pans out. Well, if you want more of it, I suggest you to read a detailed article which was published by me, authored by me, published by Taxmann, by clicking on this link. So we'll be sharing PPT as well, which you can go through. And obviously, if you are interested to read more into the nuances, then you can go through my article as well. All right, thank you so much. Thanks for your patient listening, and have a stay safe. Take care. Yeah, bye.